Welcome to our second lecture covering Module 3, which is our first introduction in a deep way into what Title VII holds for us as employers and employees. In our first lecture, we covered the history of the Title VII, kind of how it came to be a little bit and what the legal and social environment was at that time. And now we're going to start really talking about the nuts and bolts of Title VII. So let's go ahead and begin. So under Title VII and employer, and before we go any farther, whenever we see a word like this, we don't think to ourselves, oh, I know what that word means. We always think to ourselves, what does the statute provide? And as you, I hope, remember, you have to have at least 15 employees in order to qualify as an employer under this statute. And of course, the term employee is also defined. And so those 15 folks can't include independent contractors, for example. But going forward, we're going to assume that we've satisfied the employer requirement. And now we're going to think about what the employer can't do. Well, the employer can't discriminate on these bases. Can't discriminate based upon race, color, sex, which can sometimes be called gender, religion, and national origin. These are the protected categories under Title VII. Now, things that Title VII doesn't include age and disability. There are separate statutes that cover these. This is the Age Discrimination in Employment Act, ADEA, and this is the Americans with Disabilities Act, the ADA. In addition, affinities are not covered. So imagine that I am a vegetarian or a vegan. Unless it's part of my religion, I am not protected from discrimination on that basis. So say I were a Hindu and part of my religious observance was to be a vegetarian or a vegan, then my Hinduism would be protected. And as my vegetarianism is a component of that, my vegetarianism would be covered. But if I were, say, an atheist or a Mormon or a Lutheran who is a vegetarian, then that would not be covered as a religion, obviously. And so therefore, this would not be a protected category. Another affinity group could be my political views. Maybe I'm a libertarian. Maybe I'm a socialist. Maybe I'm a Republican. Maybe I'm a Democrat. Those categories are not protected. Now, obviously, if I were employed with the government, my free speech rights under the First Amendment would protect me. But again, we're focusing upon private employment in this course. And so always assume my answer assumes that the employer is private unless I say otherwise. And if at any point you're uncertain as to how that would affect a public employer, feel free to stop by my office hours and I'll be glad to talk about that. Now you may notice in your notes, either your study guide or the PowerPoint, whichever you're using, that I also have on this list in the version that you have or may have sexual orientation and transgenderism. I removed that from this list because, of course, there's been a decision made by the U.S. Supreme Court, actually two decisions, that have changed the law in this area. Title VII does not expressly mention sexual orientation, gender identity, or gender expression, or transgenderism. It uses the term sex, but the U.S. Supreme Court has held that the term sex encompasses sexual orientation, gender identity and expression, and transgenderism. So by extension, these are now covered categories under Title VII. This section is new, and you may need to add it. And then again, you'll want to remove sexual orientation and transgenderism from this list above. Okay. So as I said, we're going to talk in a lot more detail about sex and about disability in later presentations, and also about sexual orientation and gender identity and transgenderism in later presentations. So we've talked about what characteristics about a person are subject to protection under Title VII, but we haven't yet talked about what employment decisions are protected. And the short answer is all of them. It's hard for me to think of any decision that isn't protected under Title VII. Hiring, both the decision to hire, the method in which somebody is hired, the decision not to hire somebody. Promotions, demotions, the decision not to promote, the decision not to demote. Training, what training is available, how it's presented. Discipline, including letters put in a person's files, suspensions, last chance agreements, performance improvement plans, all of that would be covered. Compensation, both the amount of compensation, how that compensation is figured. Benefits, what benefits is this person eligible for, what types of copays are involved, what is the scope of the coverage, any aspects along those lines. Discharge. Now, discharge is by far the most common area here. I would say 95%, probably more than 95% of all Title VII lawsuits have to do with discharge. These other areas, yes, they can result and have resulted in lawsuits, certainly, but this is by far the most common basis for Title VII action. Classification can be several different things. It could be whether a person is classified as part-time or full-time. It can be whether that person is classified as first shift, second shift, third shift. It can be whether this person is classified as a supervisor or a line worker. It could be what the internal classification system is within the employment situation. For example, an employer might have levels. You're a level 7. Somebody else is a level 8. Another person is a level 9. It may be that being at a higher level gives you, or lower level, depending upon the system, could give you more perks, more position components, make you more eligible for promotion or things along those lines. So the classification is somewhat of a broad category. And then we have the ultimate broad category, which is other terms and conditions of employment. And this could extend to things like access to bathrooms, access to break rooms, access to lockers, things along those lines. So it's difficult to think of anything that isn't included in this category. I do want to flag one thing, and we'll talk more about dress codes later on, but while dress codes are covered by Title VII, they certainly get less attention and less focus than other aspects. And I think the reason for that is that the idea is that, you know what, a person can adapt to a dress code. If they don't, they may prefer to wear, green, but if the color at this office is brown, well, then that's what you ought to wear. And so the idea is this is something that a person can accommodate pretty easily. Most dress code cases relate to religion, where a particular item might be required by a religiously observant person, and that is outside the dress code. For example, a Jewish male may want to wear a yarmulke, or he may want to keep a beard. A Muslim employee may want to keep a beard. A Jewish employee an Orthodox Jewish employee might want to have uncut earlocks. A Sikh employee might not cut his hair or her hair, and that may raise issues, and it's not so much dress code as appearance code. So there's lots of different areas relating to religion is usually how these come up. And sometimes there are safety components with respect to that. A case that has some relevance to this area is Ali versus Mount Sinai Hospital. In this case, the court didn't really have a lot of sympathy for Mr. Ali, unfortunately. He, according to the court, failed to offer any evidence that the hospital enforced its facially neutral dress code in a discriminatory manner. It doesn't mean you can't win a dress code case, but it's one of those things that the employer is likely to kind of say, get over yourself, dress the way you're supposed to. and employers have been permitted to have policies in which the women must wear skirts and the men must wear pants, for example, or the women are expected to style their hair and wear makeup and the men aren't. Things like that are usually not going to raise a discrimination claim unless it involves a significant financial investment or a significant time investment. We'll talk more about this when we get to the sex discrimination section and the religious discrimination section in other modules. So again, we've already talked about employers, but as we said, private employers with 15 or more employees, again, not independent contractors. Unions also have to comply with Title VII. And of course, unions oftentimes are employers, although local unions, the union local usually does not have 15 or more employees, but in its relationship with the workers that it represents and the collective bargaining agreements that it manages, with respect to those workers, it has to comply with Title VII. And then there are joint management and labor committees. That's kind of beyond the scope of this class. We'll talk a little bit about related concepts when we get to the labor section. Employment agencies. Many times employers and employees or potential employees use these in order to make that connection, to get that job. And obviously, if employment agencies were able to discriminate or prefer a particular race or sex or something like that, it would really undermine Title VII generally. And so they are required to follow that, even though they may not have 15 employees. And even though usually their quote-unquote customers, the people who are seeking a position aren't really the employee of the employment agency. And then, of course, state, federal, and local governments. In some cases, how the Title VII applies to them is different. We'll see some differences in statutory periods, but generally those individuals employed in those government entities are covered by Title VII. Okay, so as we said, as we've already just talked about, the number of employees that the employer has to have does vary from statute to statute. So Title VII requires at least 15. The Americans with Disabilities Act requires at least 15. And Texas's discrimination statute requires at least 15. The Texas discrimination statute doesn't, it's just one. There's not an equivalent of Title VII, then a separate equivalent of the Age Discrimination and Employment Act, then a separate equivalent of the Americans with Disabilities Act. It's one statute that covers it all. The Equal Pay Act, which is from 1963, so it's just a little bit before Title VII. It covers any employer that has 2 or more employees. And when we get to that statute in more detail, you'll see why it requires 2. The Age Discrimination and Employment Act, which is oftentimes called, this is, by the way, oftentimes called the EPA. That can be a source of a little bit of confusion because that can also stand for the Environmental Protection Act or the Environmental Protection Agency. But employment law people call this the EPA. And within our little coterie, that's a pretty clear term. So we call this one ADEA. The way that I keep Age Discrimination and Employment Act straight from the Americans with Disabilities Act is that this has an E in it, and so does the word age. But the word disability doesn't have an E, so there's no E up here. So if you're looking for a little mnemonic to keep those straight, at least during the early days, that's the one that I recommend. So for the Age Discrimination Employment Act, you need at least 20 employees. Is there a reason why it's 20 instead of 15? I think it's just to make things a little bit more complicated for everyone. I really can't defend it. I guess the better answer, the correct answer is that whenever Congress is passing a law, there's some trading, some negotiation that happens. And my guess is that some people decided they were willing to vote in favor of it if the threshold were a little bit higher. You are supposed to know that ADEA requires 20 employees, whereas the ADA and Title VII requires only 15. Most of the time, this isn't going to be a big issue because your clients are going to have more employees than this. But especially if your law firm supports small business owners, it can be significant whether you're on the side of 15 or 20. The Rehabilitation Act really applies to government employers as well as private employers who have federal contracts. This law isn't that important because the Americans with Disabilities Act, which came out after the Rehabilitation Act, basically provides the same protection but to a much larger group of employers. And so the Rehabilitation Act's primary relevance to non-governmental employees is going to be that the case law from the Rehabilitation Act is routinely used in ADA cases. So again, the Rehabilitation Act not so important anymore because we have a law that does the same thing with a lot heavier coverage. Then we have the Family and Medical Leave Act, which is FMLA, and it requires at least 50 employees in a particular geographic area. We'll go over those specifics near the end of the course. Because of the geographic area component, though, it is quite easy for employers to have some units that it has be covered by FMLA and some units not be covered by FMLA. Even a large employer like a Walmart will find that some of its employees are covered and some are not. And so it can be an especially tricky statute to comply with. And we'll discuss those issues when we get to that module. And then we have the Immigration Reform and Control Act, IRCA, IRCA, and it covers 100% of employers. If you have just one employee, you are covered by IRCA. So let's consider this scenario. Bob has worked for Larry's Auto Shop for quite a while. He's African American. He has applied for promotion, but each time Larry has chosen a white male with less seniority and experience. So Bob decides to file a charge with the EOC. Larry then dismisses Bob for having filed the charge. So Larry's just digging himself a deeper hole. Under these circumstances, it's quite likely that Larry will be found liable for both discriminating against Bob based upon Bob's race and also retaliating against Bob for Bob's having filed the complaint. Keep in mind that in this situation, Larry has 20 mechanics, so it's over the 15 mechanic level. If this number were 14, though, the answer would be completely different. And Larry would not be found liable under the Title VII or under Texas law because you have to have at least 15. So who seems like an employee maybe, but doesn't meet the definition of employee? Well, one would be undocumented workers. And when I use this term, I'm referring to individuals who aren't eligible to work because of their immigration status. They may be here lawfully, but don't have a lawful ability to be employed. Or they may be here without the correct documentation. Maybe they overstayed a visa and the visa is not expired, or maybe they entered the country without the correct visa. These individuals cannot collect certain types of relief, such as reinstatement and back pay, if they are successful in the lawsuit. The idea being, well, they shouldn't have been earning any pay anyway, and so therefore they shouldn't be, I'm going to say use this term, I'm making the argument, I'm not defending the argument, that they shouldn't be, quote unquote, rewarded for violating the laws. And of course, the law that they would have been violating would relate to IRCA and other related laws. We'll see that how undocumented workers are treated varies significantly from statute to statute, and it is my opinion that it varies in part based upon the current environment in the United States and what people's current thoughts are about undocumented individuals. Again, we already talked about employees who work for smaller companies under 15 are not going to be protected. And again, it's when we think about 15 or more, you always have to stop and say, wait a second, do they also meet the other part, 20 or more calendar weeks in concurrent or preceding calendar year? And so it's not just a moment in time. You have to look at a significant period of time to see where the 15 applies. So when you are dealing with an employer that's close to the bubble, who's had periods of time of being under 15 and periods of time of being over 15, recognize that it's a more complicated formula than simply count how many heads you got there today. Also, individuals who are not U.S. citizens who work for U.S. companies in the United States are protected by Title VII, but non-U.S. citizens who work for U.S. companies who are employed outside of the United States are not protected. Now, that was complicated, so let me say that again. So if I'm a U.S. citizen and I work for a U.S. company, I'm protected by Title VII in the United States and abroad as a general rule. If I'm not a U.S. citizen and I work for a U.S. company and I'm in the United States, I'm protected by Title VII. If I'm a U.S. citizen and I work for a non-U.S. company and I'm in the United States, I'm protected under Title VII. If I'm a non-U.S. citizen, but I'm here legally, and I work for a non-U.S. company in the United States, I'm protected by Title VII. Here's when I'm not protected. I'm a non-U.S. citizen working for a U.S. or non-U.S. company, doesn't matter, and I'm outside the United States. Then I'm not protected by Title VII. I may well be protected by the laws in the country where I'm working, but the United States law doesn't have a sufficient extraterritorial requirement that would cover me, a non-U.S. citizen outside of the U.S. Generally, U.S. citizens are going to be covered if they are employed by U.S. companies. So if I'm a U.S. citizen employed by a foreign company outside the United States, I'm not covered. But if I'm a U.S. citizen employed by a U.S. employer, generally I'm going to be covered outside of the United States unless local law specifically prohibits compliance. So for example, in Saudi Arabia, there are rules that require a segregation of men from women in the workplace. That would be a violation of the other terms and conditions of employment. It would be a very clear violation of Title VII. But that U.S. employer would not be able to say, okay, well, we're going to comply with Title VII, because, of course, the local Saudi officials would say, well, it's unlawful for you to mingle men and women in the same workplace. And so Title VII does not put American employers in the position of having to choose which law to violate. That's not obviously a very fair position for the employer to be in. But it's relatively few times that local laws specifically contradict Title VII. And one thing that the law does, or this law, Title VII, doesn't provide is that American employers can't say, well, we're following local custom in this area. If it's not a law, if you can't point to a particular statute, then Title VII is going to apply when it's a U.S. citizen working for a U.S. company, even outside the United States. And again, we'll talk about this in more detail later on, but this is the standard. Generally, employees of religious institutions, associations, or corporations hired to perform work connected to carrying on religious activities, they are not going to be covered by Title VII. We'll talk more about the ministerial exception as well when we get to the religious section. Members of communist organizations are not considered employees. Employees of private clubs such as country clubs are not covered under Title VII. And this is an interesting one. Native American employees living in or around Native American reservations are not covered in all circumstances. This is a very technical aspect having to do with the national sovereignty of Native American tribes. So I'm not going to do a deep dive in this because it's not something that comes up commonly. Just know that there are different rules when you are right around a Indian reservation or an Indian nation. So here we have Mary. She's a U.S. citizen, and she's employed by a U.S. company in England. She's laid off. She feels like it's because of her sex. So because she's a U.S. citizen employed by a U.S. company, albeit not in the United States, she is still entitled to pursue a claim under Title VII. Let's consider Bob's situation. So Bob has extensive musical training at a non-Jewish place of higher learning. He applies to be a cantor, which is a religious leader who sings scripture in a Jewish synagogue. He applies for that job. The synagogue says, well, no, to be a cantor, you may be an awesome singer, Bob. You may be technically very fluent in Hebrew and be very talented in communicating the liturgy, but you're not Jewish. We'll assume for the sake that Bob is Baptist, but obviously that could be any religion other than Judaism. Bob files a claim saying, I would be an awesome cantor, but again, the synagogue could defend itself using the ministerial exception, because this is a role that is tied to ministering to the members of the congregation of the synagogue. It's appropriate that the synagogue can limit its ministerial staff to people of its faith, specifically Judaism. And it could be more specific than that. If the synagogue is Orthodox Judaism, then they could say, well, we're not going to accept Reform Jewish individuals or conservative Jewish individuals. Similarly, if it's a Baptist church, the Baptist church can say, we only want Baptist ministers. We don't want Methodist ministers. We don't want Lutheran ministers. We don't want Episcopalian ministers. So the denomination or the religious community can pick what the requirements are for those ministers. So in this example, Mary is a Canadian, so she's not a U.S. citizen, but she works for a U.S. company in London. Because she isn't a U.S. citizen and she's not living in the United States, Title VII does not apply to her. Now my guess is in Great Britain there's some kind of equivalent law, so I'm sure that Mary can file a claim on that basis. She may even be able to file a claim under Canadian law, and I don't know about that, but she would be out of luck under Title VII because she isn't a U.S. citizen and she's not in the United States. So I hinted at the Native American preference exemption. I'm not going to go into a lot of detail on it, but I guess I had a little bit more detail than I had thought, so good. So the idea is that in and around Indian reservations, this is actually another nation. In many cases, historically and even today, there can be significant unemployment and underemployment of Native Americans in these locations. And so the idea here is that the Indian nation may want to encourage the employment of Native Americans in those areas. And so it is okay for employers, even private employers, to prefer Native Americans to non-Native Americans of any other race. So a Native American applies, and I have an African American, a Caucasian, an Asian American, and it just so happens that the Native American isn't the most qualified. I would still be eligible to hire him or her over the more qualified African American, Caucasian American, and Asian American. One thing that the exemption does not permit is it does not permit the employer to prefer a Cherokee over a Sioux or a Nez Perce or some other tribe of Native Americans. And it doesn't, obviously, the area around that reservation would be the reservation of a particular tribe. So most likely, if it's right around a Sioux reservation, most of the Native Americans are likely to be Sioux Native Americans. But that wouldn't have to be the case, and there can't be a preference within that category. So an interesting issue is the identity Native American, is that a national origin issue or is that a race issue? And it's somewhat undetermined. Certainly it's protected under Title VII, but whether it's protected as a race is a matter of some openness. And the reason that it matters is that Section 1981 has unlimited damages. And so, of course, it does apply to national origin as well. So, again, it's a little bit of a gray area. If you are on the plaintiff side and you have a client who believes that he or she was subject to discrimination because he or she is a Native American, then you ought to advance the claims under national origin and race, and I would even argue under color, and possibly, depending upon the circumstances, maybe even religion. Here's an example of a scenario. Mary owns and operates an inn near the Lumbee Indian Reservation. She favors Indians when hiring for job positions in the inn. So she will pass on a more qualified non-Indian candidate in favor of a less qualified Indian or Native American candidate. That does not violate Title VII, but if Mary weren't near the Lumbee Indian Reservation, she would not be permitted to do that. So one thing about Title VII is that the statutory period is quite limited. For private sector employees, you have usually 300 days, and I made this change. I had 180, which is technically correct, but it's better to say 300 because most states, including Texas, has an FEP agency. And when you have an FEP, a Fair Employment Practices Agency, or a Section 704 agency, then the statutory period becomes 300 days. For states that don't have it, the statutory period is 180 days. But most do have it, so it's really at 300 days. There's also a federal deadline, which is quite a bit shorter. Federal employees are covered by Title VII, but you can see they only have 45 days to make their complaint. Now let's say that you have a client that has been slow and maybe 300 days have passed, or maybe it's a state that only has 180 days. Well, you still have the opportunity, if it's a race or national origin claim, to advance under Section 1981 because the statutory period is 4 years. So we've seen two big advantages to Section 1981. Number one, uncapped damages and a 4-year statutory period. So for those two reasons, it makes sense to include Section 1981 in any kind of race claim or national origin claim. It can't hurt your client. It can only make your client's case better. We're going to talk about the Lilly Ledbetter Fair Pay Act later on in more detail, but I'm going to introduce you to this idea because the statute of limitations generally in legal life, but in this particular practice area, employment law specifically, can be a really tricky thing because many times decisions are made about employees about which the employee is not aware. Imagine for a second that I am denied a promotion. Well, I may not even know I was being considered for the promotion. I may assume that nobody knew I was interested in the promotion, that I wasn't considered. Or it could be that everybody else got a wage increase except for me, but nobody told me about their wage increase. Or it could be that when Bob was hired on, Bob, who has less experience than I do, and Bob being a man, I'm being a woman, he was given a higher wage rate. I don't know what he's being paid. So many times the employee may not know about the discriminatory act until months or even years after the fact. Well, that's what happened to Lilly Ledbetter. She actually found out several years into her employment, in fact, at the end of her employment, that when she was hired, she was offered a wage that was significantly less than men who were hired around the same time and who generally had the same qualifications she had. And so when she became aware of this, obviously she was outraged, because it wasn't just that she was hired in at a lower rate, but over time, when people got increases, many times it was a percentage increase. We're giving you a 2% increase. Well, if Bob started off earning $1 more than Mary, and if both of them get a 2% increase, well, now Bob is earning $1.02 more than Mary. And then the next time there's a 5% increase, now he's earning $1.07 more than Mary. It just gets worse over time. And yet, the court initially said, the U.S. Supreme Court initially said, before the Ledbetter Fair Pay Act, that Ms. Ledbetter had to file her claim within the statutory period of the date that she began working. And of course she said, I didn't know what was going on then. How could I have known? It was a secret. So what the Congress did to change this result is it said, well, every time people get a new paycheck, that's a new discriminatory event, if that paycheck was based upon that initial calculation. And so you don't get to go back to the very beginning and get back all those lost wages. You're still going to be limited to a 300-day look-back period. But even if the initial pay established was outside of that 300 days, if the effects of that decision are still being felt in your pay in the last 300 days, then you can potentially recoup the lost pay that you lost for those 300 days. Kind of a confusing concept. We'll talk more about that later on. Here are some good terms to put into your Quizlet. A claimant. This is the term that we use when the person is filing a charge of discrimination. So this is the potential plaintiff or the employee. We call the person a claimant, or perhaps even more commonly, we call the person a charging party, because we call the document they file the charge of discrimination. So we call that person the charging party. The respondent is the employer. Sometimes that person is referred to as the responding party. And you can see where that name comes from. It's the person who's responding to the charge filed by the charging party. The EEO investigator is the employee of the EEOC or possibly the state agency, and his job or her job is to investigate the charge filed by the claimant. Employers, in addition to complying with Title VII in terms of not discriminating, they also have to post posters that provide that information about the requirements of Title VII, provide the information to employees. So employees know their rights under the law and also know how to contact the EOC to learn more about their rights and to file a charge of discrimination. Generally, these posters need to be in two places: where applicants are likely to go. Maybe there's a place within the facility where applicants go to submit their application. And of course, if an applicant is submitting it online, then he or she would submit it on a website, then that website needs to provide this information. Then the second place that these posters need to be is where employees gather, maybe at the time clock where they punch in, or maybe in the cafeteria or the break room where they congregate, or maybe where their lockers are, a place that employees routinely go. Many times these two locations are the same location, and so you don't have to have two sets of posters. If an employer doesn't have the posters up, then there can be a fine based upon the number of days that the posters have been absent from the walls. It can also be evidence that the employer isn't interested in complying with the Title VII, because one possible interpretation of the absence is that the employer didn't want its workers to know about its rights under the law because it was not obeying the law with respect to Title VII. And in fact, many of the laws that we'll be talking about in this course do have a poster requirement. And the reality is that employers typically need to have several different posters out. And we'll talk more about postering later on in the course. But the requirements about posters are not the only reporting or postering requirements that exist. Most employers need to submit something called an EEO-1, and this is an annual document that provides information about the demographics of its workforce, giving information about the race, the sex, and not just of the entire workforce, but breaks the workforce down into various groups, into various categories that are established by the EEOC. If you ever go into a place of employment, many times one of the first questions you're asked once you start is, well, what is your race? You may have wondered, why is that relevant? Well, that's so that entity can go ahead and complete the EEO-1 report. There are some differences between workers that Title VII does permit. And so, as we said before, there are good reasons to discriminate. To discriminate based upon quality and quantity of work makes a lot of sense. So let's look at what some of those are. One is if a company has a bona fide or a legitimate, we'll say, seniority system. So if it happens that in this particular workforce, there are more Caucasians who have longer service than African Americans. And so as a result, the Caucasians are more likely to be promoted based upon the seniority system, or maybe less likely to be laid off based upon the seniority system. That is a permittable distinction. It's okay to follow the seniority system, even if it has a disparate impact upon a certain protected group. Merit pay differences that reflect the value of the work that that particular person performs. For example, if I generate a lot more sales than Bob, then it makes sense that I'd be compensated more. Or if let's say I work in a factory where I sew blouses. If I sew more blouses in an hour than Teresa, I ought to be paid more than her. It's also okay for companies to give cost of living differentials. It's more expensive to live in San Francisco than in Frisco. It's more expensive to live in New York City than it is in Idaho. And so it's reasonable for an employer to pay different rates based upon the cost of living. There are some additional exceptions under the Equal Pay Act. Again, that's that law from 1963 that relates to sex discrimination in terms of wages. And we'll talk more about that when we get to the sex discrimination section. It's also okay for employers to prefer veterans. And of course, this tends to have a disparate impact upon women because while there are many women who are veterans, certainly a higher percentage of men are veterans than women. And so as a result, men typically benefit more from the veteran status preference, but that is permitted. Then there are certain treaties that we have with foreign nations that also permit some distinctions there. That rarely comes up in real life. There have been amendments to Title VII. Several of them have happened. One happened in 1972, which extended the protections of Title VII to government employees. You don't need to know this one. All you need to know is, I should say, 1972. All you need to know is the Title VII covers both private sector and public sector employees. You don't need to know that wasn't part of the original statute. The Pregnancy Discrimination Act you do need to know a little bit about. You don't need to know its year, but it is an amendment to the law. And many times amendments to discrimination laws happen because Congress disagrees with the decision that the U.S. Supreme Court makes and how the U.S. Supreme Court has interpreted the discrimination statute. We talked about that with respect to Lilly Ledbetter, and that is also why we had the Pregnancy Discrimination Act. I had a typo in the version that I posted. I left out the word not, which is a really unfortunate word to leave out. So be sure to add that word into your version. Okay, so obviously pregnancy is a condition directly related to sex. Only women can get pregnant, right? So as a result, it is Title VII was amended to include pregnancy specifically. Women are protected from discrimination because of their pregnancy or their decision not to become pregnant. The woman's decision to have an abortion is also protected under Pregnancy Discrimination Act. Now, the Pregnancy Discrimination Act doesn't do two things that I want to flag for you. The first thing it doesn't do is it doesn't give the woman time off to recuperate from delivering. So there is no paid or unpaid guaranteed time off in the Pregnancy Discrimination Act. We have that for many employees under the Family and Medical Leave Act. So there is protection there, it's just not through this mechanism. Right? So sometimes it's important to know not just what the protection is, but what statute the protection is found in, because what agency you go to complain and what remedies your client might be entitled to vary. For example, the Family and Medical Leave Act is administered by the U.S. Department of Labor, Wage and Hour Administration. The EEOC doesn't have anything to do with it, whereas the Pregnancy Discrimination Act is administered by the EEOC. So you'd end up with in the wrong office if you were to try to assert the Family and Medical Leave Act to the EEOC. The second thing the Pregnancy Discrimination Act doesn't do is it doesn't have any kind of reasonable accommodation requirement. Let's say I'm pregnant and my doctor has given me a lifting restriction. I'm not supposed to lift anything over 25 pounds. Well, an employer can accommodate me, but the employer is not required to accommodate me under the Pregnancy Discrimination Act. We'll talk more about when and if the employer has to accommodate. It's a rather subtle, complicated issue, but the statute itself doesn't require the employer to offer any type of reasonable accommodation. So be sure to add the not here. Then we have the Civil Rights Act of 1991. Again, you don't have to know this date. This is the one that we've talked about 2 times earlier. We talked about how it prohibits race norming in its tests. Let's see, where do I have that here? Yeah, race norming. Here's that one, which again is a definitional term. And we also talked about how it extended the scope of the Civil Rights Act of 1866 to private employment situations. But these are the rock stars of the law. It now permitted, but before 1991, there were no jury trials in Title VII cases, but it extended the right to jury. So in other words, the judge decided the merits of the case. And so in 1991, extended to plaintiffs the right to request a jury trial. It also allowed compensatory damages and punitive damages, although there are caps for these. The maximum amount for the largest employers for both of these combined is $300,000 under Title VII. Again, under the Civil Rights Act of, under Section 1981, they are unlimited if the claim is national origin or race related. We've already talked about the extraterritorial application. Let's see if there's anything else we need to talk about. We've talked about job relatedness and business necessity. Okay, I think the rest of those we can probably pass on. So at this point, we've covered our first 2 topics. We've talked about the history and we've done an overview. In our next lecture, we're going to discuss anti-discrimination statutes that came after, specifically ADEA, ADA. We're going to discuss a little bit of the theories of employment discrimination. A fair amount of this is a repeat of what we talked about before, so I'm going to go through it pretty quickly. And then we'll talk about the EOC charge process, something I've talked about a little bit, but we'll do a deeper dive in this section. I thank you for your attention. I hope this information has been helpful for you. Have a wonderful day.